Securities and financial planning offered through LPL Financial, a registered investment advisor. Member FINRA SIPC. The opinions voiced in this show are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine which investments may be appropriate for you, consult with your attorney, accountant, and financial advisor or tax advisor prior to investing.
Welcome to Planning for Win Financial Guidance in Life. I'm Kevin Pinkley. Thank you for joining us today. Today we'll be discussing a post-divorce checklist, and Ernie Martin is joining us today. Thank you, Ernie.
Thanks for having me.
And Ernie, for the listeners to get in touch with you, how would they go about doing that?
I work for a firm called Currier and Martin. That's Currier and Martin. You can reach us by telephone at 281-890-7090, extension 103. That's my extension. Or on the web at www.curriermartin.com.
Thank you, Ernie. I wanted to first kind of lay the groundwork of what in the world is a post-divorce checklist. So what we're going to be talking about is a couple have already had a divorce, the paper's signed, the ink's dry, everything's been agreed to, the court signed off on it, everybody's going their different ways, property's divided, and they're done. And they can move on with their independent life and continue. But there's a few things that need to be done, and it's at a point in time where you probably think nothing needs to be done and I really don't want to do anything. But what we're going to be talking about is examples and some issues that come up that when people come in their offices afterwards, that maybe they didn't attend to this checklist, if you will, afterwards, and there's some issues there, some problems. So we're going to come up with some suggestions on you've just remedied a situation and now you're on your own and you don't need to create a new situation moving forward that you might not be aware of. Right, Ernie?
That's correct. That's correct. And as they say, it ain't over till the paperwork's done. Mm-hmm. So more paperwork at the end of a divorce. When you start with the premise that a lot of divorces are really life-altering events for folks, okay? They're shutting down one aspect of their life that might have filled decades, and they've got to step into a new life, a new aspect of life, and there is transition to do that. Now, let's back up a little bit, and let's look at things as how much can we get done during the divorce as opposed to putting it off till the end. And that's one of the things that I try to do is get these things done during the divorce so that at the divorce hearing, the judge is either signing off on certain paperwork or that paperwork is essentially done. Maybe we have to hold off on actually disseminating it, but it's done and ready to go, okay? And we have signatures on things as well. That's very important, okay? If you're not going to do that, if you're not going to get some of this minutia paperwork done during the divorce, and you're going to need some cooperation after the divorce with your now ex-spouse, it's very important that you put into the decree instructions or direction from the court that the parties are going to execute the following documents. And we'll laundry list several documents that we are counting on the other party to sign after the divorce. And the reason that we do that is because that creates an enforcement issue. That creates the ability for the court to enforce it. So after the divorce, if the aggrieved spouse won't sign certain transfer documents, then we can point at it in the decree, we can take it to the court, and the court will either sign them for them or, throw them in jail or whatever they feel they need to do.
Well, you mentioned something important, Ernie, that if couples think their spouse isn't cooperating during a divorce, try to get them to cooperate after the divorce when, as you said, those details aren't into the decree and in the paperwork, to make them cooperate, and there's teeth to it, if you will, because people's participation drops off even more after the divorce, don't you think?
Absolutely, absolutely. And another thing to be mindful of is that we have folks that maybe they're unrepresented during the divorce. Maybe they didn't get the best representation, the best communication with their attorney, what have you. But the divorce is done, and then they don't realize until maybe years later that they needed to sign some documents. They needed to submit some documents. Maybe they needed to get some documents from the court and forward those documents to certain people to actually make the transactions complete. Right? The money's not there until it's in your bank account. It doesn't matter what the decree says. So,
well, the way I would say that, what you're saying, Ernie, is the follow-up.
Yes.
So you have people come into your office after divorces that you didn't represent. We have people coming into our offices, and they'll say something like, hey, I can't sell the house now, or I can't refinance the house, or I'm still waiting for this quadro, which is a transfer of assets from my spouse's 401k, and I haven't talked to my attorney for the last 8 months. So, I mean, it's not a given that you've hired somebody to do your divorce that they were the right person, okay? So, I mean, the people on these shows certainly don't fit into that category, but just because your divorce is, supposedly finished and you had someone representing you doesn't mean the follow-up is going to be there.
That's right.
And it's going to be done. And my experience is that's quite common. And sometimes it's 2 months after divorce, and then sometimes it's years after the divorce that, these spouses are still trying to wrap up these loose ends, and they either can't or it's difficult and there's no communication. So I guess what I'm saying is, listeners, you need to, find the right team to work with, and these issues don't happen, but they're just all too common, I'm afraid.
Yep. And the listeners should understand something as well. The court or the law affords limited time to re-involve the court. So if you have post-divorce issues in transferring property around and you don't act in a timely manner to get these done, you can lose the ability to get them done, period. Statute of limitations apply. Property division in Texas, post-divorce property division issues 2 years. 2 years, and then a window slams shut. And it's like any other statute of limitations. Sorry, it's a harsh rule. It's a good rule to know. So again, the idea is to make sure that you are doing all of these housekeeping matters that seem like boring minutia, but like I said, until things are officially transferred to you, you really don't own it. Let's talk a little bit about what some of these items are, okay? I'm going to kind of focus on some of the broader items. There's, really the list is somewhat endless of all the little details you got to take care of. But, for instance, if you own a house, usually you're going to own that house if you bought it during marriage with both parties' names. Both husband and wife are going to be on the deed, okay? And likely if there's a house note, both of those parties are going to be on the house note or the deed of trust, okay? So that's a really big one, is if one of the parties is going to take ownership of that house, that they actually get that house put in their name. And this is what we do. We call a special warranty deed. That's where one spouse is transferring to another. Now, again, this is one of these items that can be done, created, signed during the divorce proceedings, usually towards the end. We don't record that with the county. Every deed must be recorded with the county to be effective. We don't record those with the county, though, until after the divorce. But oftentimes when I'm handling a divorce, I'll have that deed done, I'll have it signed, I'll have it ready to go. As soon as the judge says you're divorced, I record it with the county. That way it gets done, and I don't have to worry about, my end, malpractice, okay, really. Again, the decree might say that party A is awarded the house. But unless that deed is done, the county clerk says, no, party B still owns it because that's the only deed we have on file. An accompanying document that goes with the special warranty deed is what we call a deed of trust to secure assumption. Again, an important concept for people to understand. Any third-party creditors out there, be it a mortgage lender, a car lender, credit card company, whomever it is, when they have both parties' names on their financing agreement, that divorce decree does not change that financing agreement. The divorce decree might say party A must pay the house note. But the mortgage lenders out there going, well, we got party A and party B on the financing agreement, and we're not letting either one of them go. And the decree is not binding on us, says the lender, and they're correct. Okay. So we do this thing called a deed of trust to secure assumption, which gives the non-house owning spouse who's still obligated under the house note after the divorce some additional collection rights. Okay, it's not a great remedy, but it's the only one we have. In addition to that, though, more importantly, is it will free up that non-owning spouse's credit with a divorce decree that says party A must pay for the house, and with a deed of trust to secure assumption, new loan officers, new lenders are going to look at that and say, we're going to pretend like this debt isn't on your credit. This debt that you already have on this house isn't on your credit. And it frees up their financing if their credit's otherwise good, okay? So those are two just exceedingly important closing documents that must be done to complete the decree. They're done, again, they're recorded after the divorce, okay? But if you don't do it in a timely fashion, again, you run the risk of your spouse owning your interest.
Well, what I'm hearing is that, so you've got two couples divorcing, they have a legal team, then you throw in a mortgage lender, and then you throw in the credit agency. You've introduced other parties. They don't really always communicate well, and they don't take instructions from certain parties. And so this has to be done right, so that it, as you've mentioned before, that it's done in a timely manner, and there's no confusion, and you don't end up owning what you're supposed to own. So, and you know, people, I think when they don't do this on a daily basis, you're like, well, it should be real simple, and it is when it's done right, but when it's not, you can't call up the mortgage lender and in 10 minutes explain, hey, I know we're both on the title, but we're going to sell the house. We got a divorce, and you know, what do we need to do? And they're going to make sure I get the correct documents. I mean, it's just more involved than people think, but it's easy to do and it's done correct. Yeah.
Exactly, and when you do it timely, when you do it as part of your divorce, or your attorney's doing it so it's ready to go right after the divorce, it's a heck of a lot cheaper and easier at that point. Post-divorce matters, again, it's like a new suit.
Right.
You're going to have to retain an attorney. You're going to have to reserve your spouse. Again, this is all assuming 30 days have passed since the divorce. You're going to have to, it's basically a new case. And you're going, well, it's all part of the divorce. Well, yeah, but it's also a new case at this point because the court has lost their plenary power. This is 30 days after a judgment, okay? Now, you mentioned another document that is, again, is exceedingly important if you have one of these, but the quadro. You mentioned 401k. You know, it applies to any ERISA retirement account, any kind of employment type of retirement account. So a qualified domestic relations order, or acronym QDRO, QDRO, is really, it's for sure the best way to divide an ERISA retirement, and in some cases the only way to divide a retirement account, such as a pension account. You can't divide it any other way. Now, a 401k, okay, if you're foolish, you can liquidate that 401k. You're going to pay taxes, usually a penalty, and you know, you're going to lose investment value if you go and do that. So folks don't go liquidating ERISA retirement accounts because you're getting divorced, okay? Not without consulting with an attorney or a financial professional. Instead, we're going to do this qualified domestic relations order. Now, these things are cumbersome, technical documents. I actually enjoy doing them. I'm one of these weirdos, but I like insurance policies too, so that's my personality. But here's the deal on a quadro that's exceedingly important, and this is why it should be done during the divorce. Two things. It really should be pre-approved by the fund administrator. So a lot of times we have a 401k, but the administrator might be Fidelity or a Vanguard or somebody like that. They make the rules.
Right.
They determine if the quadro, the document that the lawyer prepares, is what we call qualified or not qualified. If it's qualified, 2 thumbs up, it's going to pass muster with the fund administrator, okay? If it's not qualified, guess what? We've got time to fix it. And they're pretty good about telling us why it's not qualified, and here's what you need to do to make it qualified, and it's usually something fairly simple. So if we have to, we make that fix it, we resubmit it, they go, that looks good to us. But then part 2 of the equation is the judge's signature. The judge has to sign that qualified domestic relations order. Without the judge's signature, it's not effective. So again, if you wait till after the divorce to start going through the quadro process, it is very likely that by the time you get pre-approval on that document, and then you're lucky enough to get your spouse's signature on it, and then you submit it to the court, and the judge is going to say, I can't help you. You've wasted too much time. Well, we lost plenary power, right? You're going to have to file a new motion to basically reopen your case to get at that. And even that is going to be time sensitive. I'm working on one right now. We came in right under the wire. I mean, it was right when this virus thing hit as well. So it was very, very difficult. But, you know, we came in about 2 weeks before the court lost plenary power. And let me a little bit more on that because it's an interesting thing. Again, I have a client who in her divorce was unrepresented. The attorney who was representing the husband was kind of playing both sides. So she was kind of, quote unquote, helping my client with things. That attorney did not get pre-approval. That attorney made some fairly egregious errors in the quadro. Since that time, almost 2 years has passed and the company's changed hands. It's real, but we came in and again, we're having to reinitiate the case. I just sent off a revised quadro. I finally found a fund administrator, just sent it off, waiting to hear back from those folks. Generally speaking, they will approve or disapprove, qualify or not qualify the order within 60 days of their receipt of it.
Well, the interesting thing is, so Ernie explained what not to do, what you should do, and the reality of what's happening during this time frame, the person who is supposed to be receiving those funds does not have access to it.
That's correct.
So if it's 2 months, or in the case you mentioned, it's 2 years, that other spouse was expecting these funds were going to be available. Maybe they were going to need them, maybe they weren't. But what happened is they don't have access to them if they need that cash flow, and it's too bad. And the other thing is, if you don't actually need those funds to live on, to pay bills, then you had mentioned it's changed firms that are managing it, so maybe it's not invested the way you would want it to be. So it could be the combination of things. And, you know, those fund companies, they do what they're required to do, and in the HR department, if that's it, who's processing those quadros, they're trying to process it. But they have rules that they're governed by. So when the documents come up, they're like, yeah, I understand what you want to do, but we can't do it yet because you need to add a few sentences or take out a few words. And the other thing that happens is someone could work for a company for 20, 30 years. It doesn't matter. Everyone has to go through the same program, and they update those plans from time to time. So what was the policy and the guidelines 6 months ago could have changed. So, and I mean, I know you've run into this. You take some major companies in Houston and the surrounding areas, and someone filed for a divorce and everything was completed in October, and you're like, oh, we got this down. They'll be able to process the quadro, and then you get a note back that says, oh, we've updated that, and now we need some new language in there. And you're going, well, wait a minute, we just did that a few months ago. So it changes, it moves, and I don't think clients understand that there's a time frame involved there, and when it's not done correctly, you're just sitting there waiting, and you're out of control.
They say the wheels of justice turn slowly, but
Right.
sometimes they turn pretty darn fast.
Right.
So again, be mindful of that. And another thing, just to add on to all those bad things that can happen as a result of delay, particularly on a retirement account, that retirement account's solely in your ex-spouse's name. If that quadro was never submitted as a pre-approval or a signed order, as far as the 401k administrator goes, there's no reason that this person can't withdraw from it or borrow against it or otherwise take the interest of the spouse that was awarded a portion or all of that quadro. So again, you're leaving them with the keys when you do that.
Well, I'm glad you mentioned that. Often people do things they're not supposed to, and that's an example of, and then you're having to sit down with a client and say, I'm sorry this happened, that the people you're working with didn't get it completed, but oh, by the way, this person that you needed to get away from has withdrawn all the money out of the bank account because he could or she could.
Right.
And oh, by the way, it's gone.
Right.
So,
and you can sue them all day long, but this is Texas, which means collecting on that judgment might be very difficult. So again, the judge might say, "Oh, we see he took your $50,000. Here's a judgment for $50,000. He's gone.
Right.
He's gone. He's in California or whatever. It's not a good remedy. It's not a good remedy. Ounce of prevention on something like this. Ounce of prevention. Let's talk about some more of these items. This one is, in my opinion, one of the most important ones, and that's your health insurance. Okay? A lot of people, I get this question all the time. They say as part of their agreement for a divorce or what have you, Party A is going to keep Party B on their health insurance for the next year or 2 years or something like that, okay? No, you can't do it. You can only insure health insurance your dependents. Once you get divorced, your now ex-spouse is no longer your dependent, and they must, not should, but must come off your health insurance policy. So the spouse that is getting ready to lose their health insurance as a result of a divorce needs to be in tune with that. Now, I'm not an expert on COBRA, but that spouse who's going to lose their health insurance must be afforded COBRA benefits, continuing something or another, continuing health insurance benefits. It's an acronym. The idea means that the spouse who lost their insurance benefits, they can now get that same exact policy. They're going to have to pay for it, and the price is going to be quite a bit higher than what they're used to because the employer is no longer contributing, okay? But I think up to 18 months, they can qualify for that insurance, again, so long as they can afford the premium. At the same time, the spouse is going to lose health insurance benefits as a result of divorce. This should be spotted early on in the divorce, like right away, okay? Start shopping. Maybe your own employer offers health insurance benefits. If not, you're going to have to go out and get your individual health insurance. Again, assuming you want it, which if you don't want it, you are playing some Russian roulette. But okay. Any rate, long story short is that is definitely one that after the divorce, you want to be able to make a move right away. You don't want to be uninsured for any length of time at all.
Well, what tends to happen in all those meetings during the divorce is it's brought up, and then sometimes folks are like, yeah, I'll do it later when it's mentioned. Sometimes it's not mentioned. Sometimes it's mentioned when you have the incorrect team. They're signing documents, and someone goes, oh, by the way, you need to work at getting your own health insurance. And they're like, what? But the right team, they'll tell you when to do it, how to do it, and emphasize on when, because it has to be done, and because it takes time.
It takes time, and you got a budget for it.
Right.
Again, this is a major expense that is coming your way as a result of a divorce, and that is to pay 100% of the health insurance premiums out of your own pocket. That's significant. Plus the deductibles, copays, what have you, which are generally very high these days. The days of the $20 copay are basically gone. Particularly on any kind of individual policy, people are carrying $6,000+ deductibles. So,
well, and if someone does have really, really good insurance through their employer, for both spouses, often it's a shock to see what is the reality of the open market when you have to go out there and get it for yourself, regardless if you're 25 or 55. And obviously, the older you get, the more complications there are. But people are really shocked to learn, hey, I was on this plan, and now it costs how much? And they're like, well, that's more than my house note. And you're like, yeah, very well could be. And so some people aren't aware of those costs there.
Yep,
and as you said, then the conversation about the budgeting is, okay, well, Now we have to talk about this a lot because how am I going to cover this? So yeah.
Premiums all of a sudden, instead of $100 a month or what you're used to paying, it's $1,000 a month plus that huge deductible. So again, it's a very, very major issue.
Well, Ernie, I think what we'll do is, because I know what we're going to talk about next is going to take a little time. We're going to take a break right now, and when we're back, we'll continue talking about a post-divorce checklist.
Well, I think,
and we'll be right back.
Part of what makes that difficult.
Second Saturday Divorce Workshop provides unbiased information to help you understand your options and move forward with your life. This divorce workshop is for you if you are contemplating divorce, in the process of divorce, already filed for divorce, or post-divorce. You will explore the emotional, legal, and financial aspects of divorce from professionals who have guided others through divorce. For more information on this divorce workshop, contact secondsaturdaywoodlands.com or call 832-375-0900.
We're back. This is Planning for Win Financial Guidance in Life. This is Kevin Pinkley, and we're going to continue with a post-divorce checklist. And in the office, in the studio, is Ernie Martin. Ernie, thank you again.
Thank you for having me.
So where would we like to go next with the post-divorce checklist?
All right. Well, real briefly, let's talk about automobiles because almost everybody has one, okay? And almost every automobile that I know of that's street legal anyway has a title. Now, oftentimes those titles are in individual names, unlike houses, cars. You can go out and buy one as a married person and title it in your name only. It's not a big deal. And if that's the case, you don't need to worry about changing the title. However, if both parties' names are on the title, you've got to get the other party off of your title. And a lot of people completely forget this one, and the reason why is because they have a loan against the car. And guess who's holding that title? The car lender. So you forget you even have a title sometimes, all right? And you're kind of scratching your head going, well, if I don't have the title, how am I supposed to get my ex-spouse's name off of it? All right, there's two methodologies here. If you have a title, your spouse completes the back of the title just the same as if you were selling the car. Fill in the mileage, name, I think they call for an address, that type of thing. I don't believe they have to be notarized. So the non-owning spouse gives that executed title to the owning spouse. Owning spouse then takes that to their TxDOT office, and a new duplicate title is processed in that one spouse's name only, okay? When you don't have a title, then you must complete a power of attorney to transfer motor vehicle. We don't even have that in our form bank anymore because that's a TxDOT form. TxDOT manages it. Everybody can download one of those from TxDOT's website. So again, very common thing. You just have to get your spouse to sign it. Now again, if you are in a situation where there's animosity, and that animosity is going to be there after the divorce, really good idea to get that power of attorney to transfer motor vehicle or the original title signed during the divorce proceedings, okay? If you don't, at least make sure the decree says that the other party will sign that kind of document, and whatever other kind of documents need to be signed, state that in the decree. And there's a specific way that you state it with a date, time, place that party will sign instruments, okay?
I just wanted to add, so some people might be going, my car, yeah, we're going to do that. Of course we would do that. And a lot of times people are like, well, I can just do this divorce myself. Well, this checklist that you might put together yourself that things need to be done, it's probably going to be incomplete. So all these examples that we're going over today, people have literally came into our offices 2 months later, 2 years later, and said, I can't get my title on my car. I can't get my house sold. I can't get my spouse's retirement account because they tried to do it themselves. So you got to get the right team, folks, or these things won't happen.
Exactly.
And, we don't do this, but if someone came into our office and started off with the conversation, hey, I was divorced 12 months ago, and there's some things not done. I mean, we already know what those things are because we've seen it so many times.
Oh, yes.
And there's not a lot of surprises there, are there? There's a handful of things, and it's like, well, yeah, those things got brushed to the side or weren't given the attention that they needed to be, and it just happens every day.
Yep.
So
It's a very common thing. And another point on automobiles, in case anybody out there is thinking, well, it wasn't my car, right? That car was awarded to my spouse, even though my name's on the title. I don't care if I sign it or not. That's his problem or her problem, right? Yeah, until there's a car wreck in that car. And Texas can have ownership liability. Now, that doesn't mean that just because you're an owner, you're going to be found at fault for an automobile accident. You weren't in the car or nowhere near the car and didn't have any possession or use of the car. However, that doesn't mean that you might not be sued. And chances are that car is no longer on your car insurance policy. And guess what? You're paying for your own lawyer at that point.
Yeah. Well, a quick example, ran into somebody that they didn't have the title transfer. The car got stolen and was used to commit a series of very serious crimes. That person that was on the title of the car got some very unwanted attention from the state and law enforcement because that was the first place they went back to start asking questions.
Even a parking ticket.
Yeah.
You know, again, parking ticket, running a toll.
Right.
They're going after the titled owners, folks,
Yeah.
right? So, again, that's one of these things where you want your name off of your ex-spouse's vehicle and vice versa.
Well, and when it's serious, that's not something you get to explain on the side of the road, right?
That's right.
Yeah, so someone has $400 worth of parking tickets or toll roads, and they're like, yeah, everything's okay because that was through a divorce, and we never. They're like, I know, but you got to come with me anyway.
You're just carrying that copy of the decree to show to the state trooper who really doesn't care.
Right,
So
it just doesn't work.
Exactly.
Yeah.
All right, let's talk about the big one, last wills.
Yeah.
All right. Now, you don't have to do a new last will and testament just because you got divorced. But it's a really, really good idea to do that. I'm not a will lawyer. However, I can remember a few things from the bar exam. There is a process in Texas called redemption, where you have a will with your spouse. You left your spouse, their property, some of your property, what have you. Then you get divorced. You forget to do that will, or maybe something happens. You didn't have time to do your will and you die. Your ex-spouse can be removed from that will through redemption. But that is a process. That is difficult. That's going to cost your heirs money to do that. And it might be long and drawn out, and they could lose, okay? So the really smart move is right after that divorce, do a new will. If you want to carve out your former spouse from that will, which most people do, that's the time to do it, right? So again, updating the will. Very important. They can sometimes be done with the codicil. Sometimes you just want to start from scratch and do a new will. But very important piece of the puzzle here to make sure that your estate is going to be sealed up after this divorce.
Well, you mentioned the will, and then obviously there's other documents that go with it too that sometimes are even more important. Directive to physician. So meaning you're incapacitated, as an example, and you can't make your own medical decisions. You need to have someone who cares about you make those decisions, and they just need to be an adult. There's an example where familiar with someone that had a very serious accident, had been previously divorced. The will wasn't updated. Directive to physicians was not updated. This person woke up in a hospital to find their ex-spouse there, saying, don't worry, I'm taking care of everything. I know I'm still in the will. That was not a comfortable awakening, if you will. And very quickly they had their will updated and removed that person from making any medical decisions.
Oh, and by the way, I told the doctors to pull the plug out of the wall.
Well, I mean, we're laughing, but earlier that was part of the conversation because they at first thought that they were going to need to remove some limbs. And at some point they said, we need to know, the ex-spouse, they might not recover or, do we not want to resuscitate? And that person was there making those decisions. And I assure you, the person in the bed did not want that person making any decisions. And I mean, it worked out okay, but I mean, that was just a horrible example of hey, I woke up and now this person that we want no part of each other can literally make life and death decisions for you. And oh, by the way, probably have access to the assets that they thought were separated. Right. And I mean, he was literally in the hospital signing documents as soon as he can to make the changes. But
very important to get those things addressed. Another big one, though, it goes in hand with what we're talking about on the wills. Don't forget, a lot of accounts that people have don't go through wills and don't go through probates in the event of a death, transfer on death type of accounts. Those go to beneficiaries. A lot of people list their spouse as a beneficiary. Now, unlike a probate matter, unlike the will, where there's this process of redemption to remove an ex-spouse from the will because the deceased failed to do that, I don't know about beneficiaries, designated beneficiaries on instruments. You tell me, do financial accounts, do they look at it and say, oh, well, we see that you divorced this person, you just forgot to change the beneficiary and list a new one, so we're going to go ahead and take care of that after your death and give it to whomever we think might have wanted it.
The way I would explain that is what you're describing, that's a nightmare scenario. Yes. Because they have to be changed. So the short answer is they have to be changed. The removing the person from the account, if that needs to be done, changing beneficiaries have to be done immediately, because the longer you wait, things will just happen and they won't get done. Right. And if people come in with multiple statements that have been divorced 6 months or 12 months ago, I'm going to find something that doesn't have a change in beneficiary or someone's still on the title. And then the scenario that you mentioned is someone passes away, what's the firm going to do? Okay, the first thing the firms are going to do, regardless of the firms, is they're going to go, hey, let's get a hold of legal, and how do we protect ourselves?
Right. Oh, yes.
Yes, and the way that they protect themselves initially, and I mean, this is just the way it works, is they go, we're not doing anything right now, because we're going to wait and find out what's going on, what was supposed to happen, is it clear, is it not, get the documents, and that can take months or years. And when you look at, not that you ever would, but if, you know, there's different financial magazines out there and they have examples of when there's contested beneficiaries because of a death that wasn't changed, those can drag out years and years, and lawsuits are there. It is messy, 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 because no one wants to interpret what someone who's no longer here was thinking or what they were supposed to do. I mean, the argument just could be, well, maybe they cared about him and wanted to leave him on the beneficiary. We have no instruction to the contrary.
That's exactly right.
Yeah.
And again, you can't leave it to a faceless corporation to decide what was this person wanting in the end.
Right. And sometimes that decision will take place years later. Sometimes it doesn't take place at all. And sometimes it's the absolute wrong decision. So you're now wanting someone to decide that. I mean, that's just, it's really a nightmare situation. And I mean, it happens all the time. And again, you don't have access to it because the firms are like, we don't know what's going on. We're not going to do anything.
Right.
And yeah.
Moving down my list, this one is going to apply only to, generally speaking, wives, ex-wives. Again, they might have sought a name change with the court. It's usually included in the process for the wives to restore their maiden name or a previously used name, for instance, if they were married before, okay? Real simple process for us attorneys to change their name in the decree. We just, a one-sentence blurb, you know, wife's name is restored to blah, you know, name the name. Okay. Well, that's it for us, right? For the lawyers, typically speaking, but we need to advise our clients that it's now up to you after the divorce to then obtain certified copies, original certified copies of the decree. The counties, the district clerks will send those to you or sell those to you for $1 a page. Certain agencies want that original raised, sealed, certified copy to effectuate the name change. That's going to be DPS. It's going to be Social Security Administration. That's going to be immigration and customs and immigration, whatever they're calling themselves. Perhaps employers, perhaps some banks or other financial institutions. So again, there's a lot of work involved with the name change. Very little of it is done by the lawyers of the courts, typically speaking. Now, I've never had a client ask me to do all these things that was willing to pay me to do them. I've never really offered to do it, but if somebody wanted to pay me to go through that process, I probably would, but most people decline on that and they'd say, well, I'll take care of it. But it is busy work for that person that they have to complete. They have to get those name changes out. DPS does not know that your name changed. Now, years ago, it wasn't really that big of an issue because there were a lot of wives, ex-wives out there that would have different names on different documents, but we all know that, you know, your maiden name never got changed or your married name never was changed back, what have you. 9/11 happens. Try getting on an airplane now where your airplane ticket doesn't match your credit card and it doesn't match your passport or what have you, okay? Anytime you have documents when you're traveling that don't match up with that solid name, at a minimum, you're gonna have issues. And you'll be lucky to actually be able to make your trip, go out of the country, get back into the country, whatever the case may be. So again, it's very, very important these days that your name is your legal name and it's consistent throughout all of your documents. Again, and that's a very important thing that's oftentimes overlooked by people.
No, I'm glad you mentioned that because I've forgotten that. We did have someone come into the office with a long list of things that needed to be done, and at the end they go, and oh, by the way, I can't even get on a plane. And I was like, well, you know, I could see that, but that's not the first thing you think of. And this person, after the divorce, wanted to do a lot of traveling because they had done so before and they wanted to continue with it. But they were like, it's this hassle, and I just can't get all these things done. And the thought was, while this was getting, some of these other things were getting done, I'm going to clear my head and travel. And this person was like, I can't even do that. Right. So, you know, it's not one of those things that you think of would affect you, but it does.
It really does.
Yeah.
It really does. This one is a little bit small potatoes, but still it's something that has to pay attention to. Back to the marital residence, oftentimes the utilities are in both parties' names, and they did not get anything changed during the divorce. Now, after the divorce, Party A wants to get Party B's name off the electric bill or the cable bill or what have you. And that can be a real headache to do that without proper documentation. So again, it's just one of these little things that could have been done during the divorce that probably wasn't done during the divorce, and now it becomes a mountain instead of a molehill. So that's an important one that oftentimes gets swept under the carpet. Another one that's important to pay attention to, if you have a small business, oftentimes both parties' names are associated with that small business. There are going to be documents that need to be signed to transfer that business to the other party. If there's going to be, you know, that business is going to be owned by one of the parties after the divorce. And again, a lot of people don't think of it. Oh, we have a closed corporation that we, you know, never really did a whole lot with, but I want to do something with it after a divorce. Yet here it all, you know, 5 years after divorce, you realize that your ex-spouse's name's all over the share certificates, right? Well, that makes them owners.
Right.
And again, you can hold up the decree all day long to people and say, no, this is mine. The judge said this is mine. But there's just certain things that have to go along with that decree to actually effectuate ownership. Car titles, deeds to houses, stock certificates, right? Partnership agreements. All of these things are ownership documents that trump divorce decrees. And that's an important thing to remember.
Well, so you mentioned ownership. I mean, that also goes along with debt, correct?
That's correct.
So if you're not addressing debt correctly and removing parties' names on debt, then you may find that later you're responsible for debt. So we had an example that someone had, they had a small business, they had a commercial account with a supplier, and both parties weren't removed off of that availability of credit. And a number of months later, someone got a letter that said, hey, I have a $90,000 bill here. When are you going to pay it? and the person says, "Oh, you don't understand. I got a divorce. Someone else is doing that." And they're like, "I talked to that person, and they said you're paying it because they don't have any money. The account is in a joint name, and y'all never closed it or corrected it." So that's the same with a supplier or a credit card. You have to get those things taken care of.
And speaking of lenders, particularly credit card lenders, if your name is on a joint account, there's a debt there. Again, the divorce decree might award that debt 100% to your spouse. It's their problem. They've got to pay it. They've got to deal with it. Visa doesn't care. Visa's going to say we're coming after both of the parties. So where are they sending these notices of default, these notices of deficiencies, right? To the marital residence that you no longer live at.
Right.
Why are they sending these notices of default to the marital residence that you no longer live at? Because you never told them your new address. You should communicate with any creditors with whom your name is still on that dotted line and let them know your current mailing address. That way, if your ex-spouse who was awarded the debt isn't paying it, you're getting notification of it. You don't find out about it when you go to get a loan and they say, sorry, your credit's bad.
Right.
Or 2 years later, you just happen to pull your credit report and notice that the debt that was awarded to your spouse never got paid. Right. And again, the letters were sent by Visa. They did what they're supposed to do. They sent it to your last known address.
Well, as you know, a simple way to address that is what I always ask for, is that each party run a credit report on themselves, not the other spouse, just themselves, and then it lists everything that you're responsible for individually or jointly, and then you can clear that up, because what tends to happen is someone goes, God, we had that account 12 years ago and we thought we closed it, but it's still open. So that happens. Or, you always ask, how many cards do you have? And they'll go 2, and then you run the credit report, and it's like, well, it says there's 4, because they've forgotten about it, or they never received that card. And that's a way to clear it up, and that's also a way to get in contact with them. You know who you need to contact because it's on the credit report. And because the legal system and the lending system don't speak the same language, do they? They don't communicate well. Yeah. Exactly.
Speaking completely different, not even the same human languages to each other oftentimes. This is another one that comes up and surprises a lot of people. Personal property. Okay. So parties have a lot of assets, but usually the personal property, the furniture in your house, the little things are, divided kind of haphazardly throughout the divorce. Oftentimes, personal property gets left at the spouse's residence who now owns the marital residence, okay? With the notion that, can you hang on to this for a little while until I get a place? Maybe they're living in an apartment. They don't have space for that type of thing. And that spouse says, yeah, sure, I'll hang on to it for a while for you. Okay, well, time goes on. The decrees often are very generic. The final decrees of divorce are often very generic when it comes to personal property. And I'm just going to summarize here, or paraphrase. It basically says personal property is awarded to the party that has possession. So a spouse is given full ownership of the marital residence. Special warranty deed is signed. They own that residence. Guess what? They own everything inside that residence, including your personal property. You've got no written agreement with your ex-spouse that they're going to give it back. You're just kind of thinking, well, it's mine. It's not yours. And it's not titled, and it's very hard to document that is yours in any way, shape, or form. Now, 2 ways to go about this. A few ways to go about it. Number 1, do an exhibit. If you're not dividing up all of your personal property before that divorce, attach an exhibit to the decree saying, okay, party A gets ownership of all the possessions in that house, except for the items listed on Exhibit A that are owned by the other party. Now we have something that clearly identifies who owns what personal property, okay? That's one way to go about it. The best way to go about it is just to get it out of there. Okay, get it out of there, put it in a storage unit and all that. Certainly understand that if you don't want to incur that expense. So a third way to go about doing it is do a written agreement with your ex-spouse before they're your ex-spouse, saying, hey, we've agreed that the following personal property will remain at your residence for X period of time, okay? Now, if you go over that agreement, you want to get a new agreement because, again, at some point, that spouse can consider the property either theirs or abandoned. And maybe they're getting tired of storing all your stuff. They're going to sell it in a garage sale, and they're going to have every right to do that. So again, if your personal property is important to you, take it with you. Take it with you.
No, glad you mentioned that. So that's, all the things you could think of, but it's also the family photo albums. It's things that was passed down from grandma and things that you just don't want to end up in a garage sale or tossed to the curb. So it's not just things with a dollar value on them. Well, Ernie, I want to thank you. With most topics, there could always be a part 2 to this.
Probably.
But for the listeners to get into contact with you, how would they do that?
Again, my phone number is 281-890-7090. I'm extension 103. You can also reach me by email at emartin@Currier, Currier, Martin.com.
Thank you, Ernie.
Thanks, Kevin.
And thank you for listening. This is Planning for Win, Financial Guidance in Life. You can always join us the last Tuesday of the month at 1 p.m. or check us out online at Lone Star Community Radio. Thank you.
Securities and financial planning offered through LPL Financial, a registered investment advisor. Member FINRA SIPC. The opinions voiced in this show are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine which investments may be appropriate for you, consult with your attorney, accountant, and financial advisor or tax advisor prior to investing.